Now, what I'd like to do is introduce our Dean of the Law School, Lawrence Mitchell, who has been a transformative and beloved addition to our school, and we're really happy that he is here to do the welcome for General Mark Martin. Dean?
Thank you, Michael. Military commissions coexist uneasily with the rule of law. Paradoxically, perhaps, it is only in nations beholden to the rule of law that military commissions exist, for they provide the color of law to procedures and punishments that in other nations are summary and brutal. Yet, the attempt to inject some degree of law in the chaos of combat while dealing with the hard realities of war often does and has led to great controversy over the degree to which legal process is necessary and appropriate. Nathan Hale was hanged by General Howe as a spy without trial or process. By contrast, George Washington used a commission of sorts and a court-martial to condemn Major Andre. Unlike courts-martial, military courts, which are obligated to follow the rules of due process, military commissions historically have more or less made up the rules as they go. Andrew Jackson during the War of 1812, General Winfield Scott, old Fuss and Feathers, during the Mexican-American War, President Lincoln during the Civil War, President Roosevelt during World War II, President George W. Bush, and President Barack Obama, among others in American history, have used military commissions with more and often less due process, always to great controversy, and sometimes to judicial and congressional intervention. Today's speaker is a remarkable man. General Mark Martins, Chief Prosecutor of the Al-Qaeda Military Commissions, would be a distinguished guest under any circumstances, but he's a particularly special guest for this law school. When General Martins was selected to be Chief Prosecutor of the Al-Qaeda Military Commissions in 2011, a newspaper wrote, "M sent in James Bond. MacArthur ordered in the 1st Marine Division. Today, when the Department of Defense has a complex crisis requiring brawn and brains, Brigadier General Mark Martins gets the call. His latest job, reset the button at Gitmo." General Martins has impressive credentials. First at West Point, a first at Oxford on his Rhodes Scholarship. I'm tempted to say first in war, first in peace, but you know the rest. General Martins is a magna cum laude graduate of Harvard Law School, where he served on the law review with the president. He has earned degrees at military institutions, and he is a highly decorated soldier. But all of this pales beside what General Martins actually has done for us. Engaged as a soldier in regions of conflict, I think nobody has done more to bring integrity and legitimacy to the troubled institution of military commissions. He has worked to reform interrogation and detention policies in Afghanistan and to promote the rule of law throughout Afghanistan. General Martins well understands that to promote the rule of law, one must exemplify the rule of law. Our nation's efforts to fulfill our mission of seeking justice cannot succeed unless we hold ourselves to the highest standards of justice. General Martins does just that, and for that, General Martins, we thank you. Now, before asking the General to deliver a speech, Michael's asked me to brag a little bit about law school, so I'll take a couple of minutes on that. The lecture was organized by our Institute for Global Security Law and Policy, which was launched shortly after 9/11, and is currently directed by Professor Avi Cover. The Institute for Global Security Law and Policy is part of our ambitious international law program, which is much to be proud of this year. We launched the world's first international MOOC, taught by Associate Dean Michael Scharf, which had over 25,000 enrolled students. Were they only paying tuition? We are the only law school with its own international talk radio program, hosted by Dean Scharf and broadcast on Cleveland's NPR affiliate. And we recently increased our student exchange and concurrent degree programs from 3 to 26 foreign partner schools, including all of the top 10 law schools in China. Since 9/11, our law school has been actively involved in the issues of detention and trial of terrorists at Guantanamo Bay. The director of our Cox International Law Center, Associate Dean Michael Scharf, testified before Congress about reform of the military commissions. In 2005, we produced the Cleveland Principles of International Law on the Detention and Treatment of Persons in Connection with the Global War on Terror, which were signed by hundreds of leading experts in the field. And the Cox Center has hosted experts meetings in 3 conferences on torture and the war on terror, security detention, and the optimistically named after Guantanamo. Students enrolled in our War Crimes Research Lab and our National Security Lab have prepared more than 30 research memos for the Office of the Prosecutor of the Military Commissions under the supervision of Dean Scharf, Adjunct Professor Greg Noon, who served as the head of the Pentagon's International Law Branch, and the newest addition to our adjunct faculty, Jim Johnson, former Chief of Prosecutions of the Special Court of Sierra Leone. Finally, I am especially proud to say that 3 of our graduates have played key roles in the Al-Qaeda military commission trials. Navy Lieutenant Commander Brian Meitzer, class of 2000, served as Chief Defense Counsel in the Hamdan trial. Army Captain Keith Petty, class of 2002, prepared several of the commission's first cases, including the Omar Khadr case. And class of 2003 grad Mike Leibowitz, a civilian member of General Martin's staff, is currently prosecuting the Khalid Sheikh Mohammed case. This is an extraordinary law school. From this little law school in Cleveland, Ohio, go forth so many graduates to do so much good in the world. General Martins, we hope that in the tradition that you have set, we can continue to do that and continue to make our world a place ruled by law and justice. Thank you and welcome.
Thank you, Dean Mitchell, for that warm and gracious welcome and introduction. It's so tremendous to be here in this distinguished institute and law school and a tradition of international legal studies. Michael, Avi, great to see you again. Avi, in your former work in Human Rights First and our work together on the Counterinsurgency Manual, the Army and Marine Corps Manual for Counterinsurgency. And of course, Michael, who I hadn't seen for 20 years. It's hard to believe that 20 years ago we were trying to think through how an international criminal court might deal with shadowy groups of various levels of allegiance and connection to a government, might be tried for violations of international law. And your scholarship has meant so much to those of us in the field and in courtrooms around the world. So it's just tremendous to see you again and to be here. You know, come into this distinguished Institute of Higher Learning, having spent most of the last decade in rural parts of Iraq and Afghanistan. I'm kind of reminded of maybe the most famous occasion in which a backwoodsman, came to the academy. You'll remember it too from our history. It was Abraham Lincoln in 1858. He's debating Stephen O. Douglas in the senatorial campaign in Illinois. One of the Lincoln-Douglas debates occurs at Knox College in Western Illinois, then is now a preeminent private liberal arts college. Lincoln, of course, a self-schooled person, no higher education of any sort, comes to Knox. Historians say it was a pivotal moment in the lead up to the Civil War. The whole course of peace and then war might have been different had Lincoln not denounced slavery on moral terms that day. So Knox, as the legend of the debate goes, Knox had set up scaffolding. If you've been out to Knox, there's an old main building, and they wanted everyone who was coming, it's a railroad junction town, so people were coming from all over the Midwest to Knox. They gathered out in front of the old main building, and they had set up scaffolding on the second floor so the candidates could be heard and seen. So Stephen O. Douglas, comes, this compact man, gets through the window out onto this scaffolding, no problem. Lincoln, of course, tall, gangly man, was to become our 16th president in just a couple of years, kind of gets through the window with difficulty out onto this makeshift stage and is said to have quipped, "At least now I'll be able to say that I've been through college." Now, I won't be able to say I've been through the great Case Western Reserve University School of Law after this, but I'm indebted to you for allowing me to share it with you for this afternoon. It's also great to be in Ohio. My first platoon sergeant was from Ohio. Very grounded, wonderful non-commissioned officer, Irwin, California, out in the high desert. And we had trained hard all day with my platoon. Went to bed out near our foxhole. Sergeant elbows me at about 2 in the morning. He says, "Sir, look up and tell me what you see." And I looked up and I said, "Well, I see a heaven full of stars, platoon sergeant." He says, "Sir, what does that tell you?" And I didn't really know where he was going with this question, but I wanted to impress him with my profound and keen intellect. So I said, "Well, astronomically, platoon sergeant, it tells me there are billions of stars and perhaps trillions of planets. Theologically, it tells me that God is great and we are but small and insignificant. Meteorologically, it tells me it's a clear night, should be a clear day tomorrow, great day for training." I said, "Well, what does that tell you, platoon sergeant?" And thought I had really impressed him with this. He was pausing. He said, "Sir, it tells me that somebody stole our tent." That was the last time I was consciously trying to be profound. And I won't try to be profound today, even though we're dealing with some profound issues, some serious and profound issues. I want to talk to you for the next 20-25 minutes about the Reformed Military Commission System under the Military Commissions Act of 2009. This is a system that the Dean's introduction indicates, just in almost every phrase and word, the connection of this system in people's minds to images formed of Guantanamo a decade ago. And yet the world's view of this system and of Guantanamo is not merely a function of just images. There were serious legal errors in the framework with which we started out a decade ago. In 2004, the Supreme Court held that detainees held under the law of armed conflict must have a meaningful opportunity to confront the basis under which they're detained. In 2006, the court held that if we are to try the great writ, the writ of habeas corpus, access to our federal courts to detainees, those cases, Hamdi v. Rumsfeld in 2004, Hamdan versus Rumsfeld in 2006, and then the Boumediene v. Bush case in 2008. Where we are now, I will submit to you, and I'm grateful to have the opportunity to answer whatever question you have, tough questions, in an academic setting where I know that you're thinking about these things carefully. It's not going to be just about slogans. I want to talk to you about these issues because where we are now is at a mature and accountable institution. That 5 different acts of Congress, and I'm talking about the 2 different Military Commissions Acts, so 06 and 09, and then successive National Defense Authorization Acts, presidents, 2 different presidents coming at this from different perspectives, and now increasingly our courts have weighed in on. This is the only lawful path forward, for reasons I'm going to mention, for trials of some of the most serious alleged members of Al-Qaeda and associated forces. So military commissions. Let me say 4 things up front, given the international perspective of many of you and being part of the great Cox Center. And I'll put this in sort of an international context. First of all, it's really important, I think, to distinguish between detention under the law of armed conflict and a criminal trial under the law of armed conflict. Okay, so detention under the law of armed conflict is the taking of a combatant off the battlefield. A regular combatant, somebody wearing a uniform, or somebody not. You have that authority. States have that authority until the end of the conflict. Not a controversial source of authority under international humanitarian law, under law of armed conflict. That's one topic, and that tends to be associated with Guantanamo, detentions in Afghanistan and Iraq that are occurring in the context of hostilities. Okay, that's detention. Then you have trial of alleged violators of international law, of the law of armed conflict. Criminal trials. Okay, so if you don't make that distinction, I find people on all sides of these different issues, if you kind of imagine 4 quadrants, you can be for the system of detention that is right now supervised by our federal courts, right? You have the habeas with regard to Guantanamo detainees. You have the habeas petitions in the United States District Court for the District of Columbia, federal court, providing independent review of the lawfulness of detention. So you might be for that system, say, and against military criminal trials. You might be for the high standard of proof, the rigor that I'll talk about with regard to a criminal trial, putting somebody on notice of charges and trying them in a criminal trial in a military commission, and against the longer-term detention that can happen even under federal court supervision, right? So you can be for one, against the other. You could be for both or against both. I have found thoughtful people all around the world in every one of the quadrants. So it's important so as not to make sort of analytical errors and first-level errors to see that distinction. Having spent a good deal of time in the law of armed conflict detention effort around the world in Afghanistan and Iraq, I am now clearly working in this area of criminal trials. So what I'm talking about today is military commissions, which is distinctly this criminal trials aspect that must be, I think, disentangled. So that's the first observation. The second is, since 2006, we have very clearly been within Common Article 3 of the Geneva Conventions. The court held, as I said, there must be you must comply with that. What was that rule? That if you're going to try an individual under the law of armed conflict, you must provide a regularly constituted court, affording all of the judicial guarantees recognized as indispensable by civilized peoples. So we are clearly operating within that international legal obligation. The third point I'll make up front is that 2 other sources of authority. We are not party to the additional protocols to the Geneva Conventions, but in early 2010, our government indicated that we were but we made clear that we were following additional Protocol 1, Article 75, and all of additional Protocol 2 out of a sense of legal, a so-called opinio juris, and those provide additional safeguards regarding the criminal trial of individuals, both in international armed conflict for Article 75, Additional Protocol 1, and non-international armed conflict, Additional Protocol 2. And then finally, military commissions can be understood as a national forum for offenses against the law of armed conflict, which is important to point out. Even our international courts, right? International Criminal Court, Article 10, International Criminal Tribunal for the former Yugoslavia, Article 9. You've got concepts of complementarity and concurrent jurisdiction. No one has conceived that national courts wouldn't have a role in prosecuting crimes against the law of armed conflict, right? I mean, the community of nations wants as many possible lawful forums in which to try those who have violated such, have committed such offenses. So those are 4 points up front that I think try to put it into context. I'll start with what they are not, okay? They are not the secret, exclusive, separate terror chamber, terror tribunal that some frankly sought 10 years ago and others feared. That's not what happened, okay? What we have now is a system that is authorized under a law passed by Congress and signed into law by the President that provides all of the protections, I would submit, that are consistent with our values. So what are they? Well, they are military courts, the system that I've been practicing in all of my career. It is a system that is regularized, a regularly constituted court by the Military Commissions Act. It lays out the procedures by which they are constituted and run. The process begins with something called referral of charges to a military commission. And it's in its first meaning, a military commission, a military court refers to that board of officers, that panel, that jury fact finder in the system. A panel of officers is the military commission. So how does the commission get charges? It's through this process of referral under the statute, formalized under the statute. It begins with an investigation coming to me, to my office, establishing in fact and evidence that someone has violated one of the 32 crimes that are codified in the Act. These are long-standing law of armed conflict violations: attacking civilians, attacking civilian objects, murder of protected persons, using a flag of surrender improperly, perfidy, treachery, terrorism in the context of hostilities. So I get evidence that one of these things has occurred. And if the evidence is admissible, if there's a reasonable prospect of success on the merits at a full trial, a full adversarial trial, I swear charges, or someone in my office swears charges. I actually then endorse the charges after reviewing them independently myself. I'll endorse them and forward them to a convening authority. Now, a convening authority in military justice is historically a commander. Convening authority is part of command. When I was a field commander in Afghanistan, I had convening authority as part of maintaining the discipline, morale, welfare, accomplishment of the mission of my unit and troops. Convening authority was one piece of command, part of the responsibility and authority of a commander to maintain that discipline and to accomplish that mission. So a commander has convening authority. The convening authority of the military commission is a senior official designated by the Secretary of Defense. It is either the Secretary of Defense under the statute or a designated officer, senior officer. That's Mr. Paul Oostburg-Sans right now, who also happens to be the General Counsel of the Department of the Navy, a senior officer, has this convening authority. He must, with the advice of a legal advisor, a trained person within military justice and a lawyer with criminal justice background, review the charges, find that the evidence shows that a crime was committed, that the accused is the one who did it, that the offense states an offense under the Military Commissions Act of 2009. If he finds those things, he will refer the case, there's that word, referral, to a military commission. At that point, the chief trial judge of the trial judiciary appoints a judge to the case to preside, has the statutory authority to preside over the case. Now, this is not an Article III independent, life-tenured independence judge. I would submit it is an independent judge, typically an Army colonel, Navy captain, Air Force colonel, Marine Corps colonel, somebody with military justice experience, who is in a separate chain of command for independence and has statutory protection from any kind of influence from people within the executive branch. Again, while not, this is the same trial judiciary that we use in our military justice system. Although not Article III judges, I would ask any of you to look at their decisions and defy you to say that they're not independent. I mean, one military commission judge did not allow Abu Ghraib to be destroyed following allegations that arose in Abu Ghraib, saw it as a crime scene, and defied very senior level even presidential direction to have Abu Ghraib destroyed for operational purposes. Also, at the beginning of the military commission's experience in 2009, the president had ordered a stay, wanted us to abate proceedings, and the judge refused to abate proceedings. So these are people who are independent, very senior, retirement eligible judge advocates serving on the bench. Okay, so you have the judge. The panel is a board of officers. In a non-capital case, it's at least 5. In a capital case, it's at least 12. And these are officers drawn from the 200,000 plus officers, active duty officers of all services serving worldwide. They are selected by the convening authority. So this isn't a Sixth Amendment jury of one's peers randomly drawn from the district wherein the crime shall have been committed. They are selected by a convening authority. Same exact statutory criteria used in military courts-martial. The convening authority, and I have a lot of experience selecting different types of panels, age, education, training, experience, length of service, and judicial temperament. So the convening authority selects a panel from amongst all those officers. So officers serving on the demilitarized zone in Korea, in Afghanistan, Iraq, post camps and stations around the United States, all eligible, and the convening authority selects them, essentially is selecting the jury pool. The jury pool. That jury is then, that pool is then subjected to rigorous examination and challenge by counsel from both sides, with challenges for cause to be liberally granted, and peremptory challenge also exercised by both sides to get an impartial fact finder. The case is then tried, and the trial process, sharply adversarial, looks very much like what you're familiar with in civilian criminal trials. Has all of those guarantees, judicial guarantees recognized as indispensable by civilized peoples. The accused is presumed innocent. The prosecution must prove guilt beyond a reasonable doubt, the highest standard known in our law. The accused is entitled to notice, specific notice of charges in a language he or she understands. The right to counsel and choice of counsel, and in a capital case, learned counsel at government expense, a right that Congress was interested in providing because of concerns relating to access to counsel in Guantanamo, a right we don't provide our own service members in terms of learned civilian counsel, death penalty qualified counsel at government expense. The right to presence. Hamdan was actually a case involving a presence issue, but a very strong right to presence at the trial. Protection against self-incrimination. Protection against the use of any statements obtained as a result of torture or cruel, inhuman, or degrading treatment. And the standard for admissibility of an accused statements is voluntariness. The right to witnesses, present evidence on one's own behalf, present witnesses, cross-examine government witnesses, witnesses and evidence that the accused is obtained with the power of the state, compulsory process of the state to get that evidence into the court in front of that military commission jury. The right to exculpatory evidence. You're familiar, those of you who've taken criminal law, and I talked to two of your 3L, those of you who are 3Ls, your 3L classmates who ran with me this morning. You were very well represented by Joshua and Graham. I know that they have learned Brady v. Maryland and Giglio. I mean, exculpatory evidence. So the prosecution has an obligation to provide those things that undercut the government's case, that may be exculpatory, tend to reduce the belief that the person's guilty, or lessen the sentence, the appropriate sentence, the severity of the crime, and then even something that would go to the credibility of the prosecution's witnesses, Giglio evidence. If it would help an advocate impeach the government's witnesses, I've got to turn that over. So exculpatory evidence. An impartial decision maker I've spoken about with regard to the military jury. Exclusionary rules. I've spoken of the exclusionary rule related to coerced evidence. But you know, this is a lay jury, right? This isn't lawyers, so there's the same concern about evidence that may be unfairly prejudicial, right? Where the risk of prejudice substantially outweighs the probative value, excluded. I'll talk about hearsay a little bit later, but we generally exclude hearsay. There are a slightly narrower aperture for hearsay than you would find in federal civilian courts. Self-representation. If you're familiar with Ferretta v. California, an accused can knowingly, voluntarily, intelligently waive the right of counsel. Don't have to be forced to take counsel. Same rule that we have in our civilian process. Protection against double jeopardy, protection against ex post facto laws, and the right of appeal. Remember I said this is a system within our larger system of democratic and constitutional governance. Right of appeal to a military and civilian court, United States Court of Military Commission Review, and then to the federal system. The United States Court of Appeals for the District of Columbia Circuit is the second level of appeal, and then by petition for writ of certiorari to the United States Supreme Court. So those are the rights afforded to the accused under the Military Commissions Act of 2009. And it's a system that is intended to deal with a defined threat. Al-Qaeda and associated forces. The 9/11 Commission called Al-Qaeda a threat that was patient, lethal, adaptive. And that's still correct, even though the organization and its associated forces have morphed. It's important to have a clear-eyed view of this, to neither exaggerate it or minimize it. It's a group that intentionally targets civilians. It uses off-the-shelf technologies that are increasingly easy to get to enable them to combine and to figure out what the weaknesses are of open societies. They can strike when they want, and they are quite patient. And while the number of casualties over a period of time might be low, it's folly to underestimate the psychological impact of the kind of crimes and hostile acts that they commit. And we are in this world where we have an overlap, right, between something that's both a crime and an act of belligerence, an act of hostilities, if illegal. So important to have this view that's neither exaggerating it nor underestimating it, because the response matters, right? I mean, this is the kind of attack and action that tempts even peaceful peoples to respond outside the law. And my sense is that's one of the most serious mistakes you can make. You've got to respond to this within the space defined by our law and by our values. Within that space, we have to be relentlessly empirical and pragmatic and use every lawful, appropriate instrument of national power and authority to deal with them. Diplomacy, economic means, sure. Intelligence, yes. And military force when necessary. On the 12th anniversary of 9/11, I was reflecting back to where I was 2 years ago, and I had just been to Tarnak Farms in Kandahar, where I was working at the time, serving at the time, and then Garmabak Gar, which was the Farouk camp in the Kandahar Hills, not too far from Tarnak Farms, which was the headquarters of Al-Qaeda, and went there with some of my Afghan partners and talked to them. We needed to put boots on the ground there. I mean, you have to rout out places where people were plotting with impunity. Military force, yes, when necessary. And I believe military commissions, which do have a long history and have been updated to become a national security and justice institution, a mature one for our time when necessary. So important to keep an eye on what is this threat, one that, again, all three branches of our government acknowledge we are in an armed conflict with. That's not a controversy with regard to domestic law. Okay, let me get you warmed up. I'll map out 6 different criticisms of commissions. They'll be familiar to you, and and then I'll take questions. Military commissions are condemned as, I call them the 6 uns: unsettled, or unfair, unsettled, unknown, unbounded, unnecessary, and even un-American. Okay, so let's start with unfair. People believe that these protections that Congress provided in the Military Commissions Act are not enough. They're not fair. They don't measure up to protections in other courts. William Shawcross, who's the son of Lord Hartley Shawcross, the British prosecutor at Nuremberg, has said that if the 21 defendants in the dock at Nuremberg were magically transported to Guantanamo, they would be astonished at their rights, privileges, and immunities. Now, given where we've come, there's been a revolution in constitutional criminal procedure. We think much differently about discovery and the ability to mount a defense. That's appropriate. That's an appropriate development. But it does cause you to think a little bit differently about the notion that they are unfair. Unsettled, this is the criticism that military commissions don't have a body of law. You know, it's not clear where you're going for your legal rules or where the judge is to look for decisions. I believe this is grossly overstated. Military commissions draw upon an abundant source of law in the Uniform Code of Military Justice and the military criminal trial practice since 1950, as well as, because the Military Commissions Act points us towards federal courts for a number of areas, as well as our federal district court decisions. Because our practice relating to pre-2006 crimes is specifically pointed under Article 21 of the Uniform Code of Military Justice to the law of war, we also must look to the international law of war. But it is to imply that that is a system that lacks the anchoring. I mean, you understand the criticism, right? Part of justice and process is a sense that you can discern what the rules are, right? I mean, it's an important principle of justice and fairness. But the judge in a military commission system can find the law and hears it. It's in a sharply adversarial process with very competent counsel. Issues are presented for decision in a methodical way with appeal all the way to the Supreme Court, and decisions are made. That's what happens in courts every day all across the country. And the law books are filled with disputes over what the law says and what it means and how it applies to a particular set of facts. That process is completely consistent with the fair administration of justice. So that's the unsettled argument and the counter that I would offer to you, but we can certainly talk about it. Unbounded, right? This is the notion that this is military jurisdiction, right? We are a constitutional democracy, civilian control of the military. That's the process, right? The jury trial, our civilian institutions of justice. And that if you have expansive military jurisdiction, this can undercut our civil institutions, be corrosive of them. Understand the concern. This goes back to Ex parte Milligan, Ex rel Toth v. Quarles, Reed v. Covert, O'Callaghan v. Parker. You're familiar with this line of criticism. The response is that this is a narrow system. Again, remember I said this is not the separate exclusive terror court that was going to handle all terror cases. This is a narrow jurisdiction dealing with situations of genuine, no kidding, hostilities. And hostilities has grip. It's a standard. If you're familiar with the International Criminal Tribunal for the former Yugoslavia practice that Professor Scharf pioneered in many ways, the Tadic case is a good articulation of what hostilities are. It has to be protracted armed violence of a scope, a nature, an intensity, duration, that a state must use its military force to deal with. That's a standard you can present evidence on. that separates out sporadic acts of violence. It really has to be armed conflict. That is actually an element of every offense that has to be proven in the military commission system. It has to be not just terrorism, right? Often spectacular violence to gain a political end, intimidate the population, et cetera, but it has to take place in the context of hostilities. The accused has to be an unprivileged belligerent. This is someone who doesn't carry arms openly, is not subordinated to a commanding officer, who causes compliance with the law of war, doesn't wear a uniform, okay? You have to be an unprivileged belligerent in the context of hostilities, and then it has to be one of those 32 offenses. I'm a big fan of federal courts. Federal courts can try some 3,000 crimes, a lot of precursor crimes, lots of things dealing with terrorism. Military commissions have a very narrow sphere dealing with violations of the law of armed conflict in the context of hostilities. This hypothetical you'll hear of the little old lady in Switzerland who signs a check, that winds up funding the Tamil Tigers, a terror group. Is the military commission system really going to haul her in to court? That is just that. It's a law school hypothetical that could never happen. It doesn't fit the law, and it just couldn't happen, okay? Okay, that's unbounded, and you've got the comeback for it. I've mentioned unknown. Okay, this is the idea that this is secret. This is transparent. There's going to be a lot of secret sessions. You think of the Kieran case. I was just in the Robert F. Kennedy Department of Justice building last week. On the 5th floor there, they tried the Kieran saboteurs in a secret trial. This is an open system. We follow the press enterprise 2 factors. In 200 hours in court that I've had as chief prosecutor, there has been a little bit more than a half hour of closed proceedings. These are on interlocutory matters pre-trial. The government's case will have no closure. It will be all open to the public. The judge in advance has to state that there's an overriding public interest for closure. And if it's a national security issue, it has to be really protecting sources and methods. It can't be justified or attempted purported justification that a law was broken or that it's somehow embarrassing. He has to preserve it all on the record. Again, it's taking place in a sharply adversarial process. All parties are going to be weighing in on it, and it's preserved for appeal. This is the press enterprise 2 factors. In Richmond newspapers, the Supreme Court said in the criminal context that the people of an open society do not demand infallibility of their institutions, but it's difficult for them to understand what they are prohibited from observing. And that's the operative principle here. This is an open system. We have 60 news organizations that cover Guantanamo. There's closed circuit TV video feed to locations in the United States. If you have an ID card with a photo, you can get in and watch the proceedings. It's not televised. We're using the same rule as in federal court and in our courts martial, but it is public and open. And there's same-day transcripts posted on www.mc.mil where you can get all of the pleadings. You can make sense of the proceedings and see what the parties have briefed and what the issues are. So difficult to fathom the unknown aspect, although one of the reasons I'm out talking to you, a very unlikely spokesman I am, is to try to help engender more understanding of the system. So unknown, unnecessary. This could be a whole discussion all of itself, right? We're in this world where something can be both a violation of an international terrorism crime and a violation of the law of armed conflict. It's just the nature of the conflict we're in with these non-state actors who are presenting as civilians. And you say, well, why can't we just do this all in a federal civilian court? Again, I'm a fan of federal civilian processes. Believe that my brother and sister prosecutors in federal courts are doing tremendous work, have had many convictions, although the numbers are sometimes overstated. They have had convictions in terrorism cases, including some cases, about a dozen, involving Al-Qaeda defendants who were operating overseas and were convicted of crimes that could have been charged under the military commissions process, about a dozen since 9/11. So why not just do it all in federal court? The analysis that one must do is look to what each jurisdiction can charge, right? This is not a novel problem. Prosecutors do this when they have concurrent jurisdiction all the time. You look to see what you can charge, what's the admissible evidence, are there any legal barriers? You can think about efficiency factors and strength of interest factors. You know, what venue are you going to bring it? Is that a secure venue? What about the jury? Is there some possibility for juror intimidation? I don't think any of these are totally dispositive. I will tell you that when I've sat around the table with my fellow prosecutors, there are actually 8 who work in my organization, 8 lifetime federal civilian prosecutors from DOJ. The no Miranda rule, we have voluntariness under the totality of the circumstances, and we do have this slightly broader aperture for lawfully obtained, probative, reliable hearsay where the accused or the declarant is actually unavailable, can't come into court. Those rules do have bearing on whether a case might be more appropriate for a military commission, but it deals with genuine operational and intelligence factors involving this threat. And it has to be in the interest of justice to leverage one of those differences. Okay, so that's unnecessary. I believe there really is a category of cases in which the best choice is a military commission. And of course, right now, we have a bar on having any detainee from Guantanamo. Congress has said, they are our legislature, has said no detainees will be moved from Guantanamo to the United States. That means the only place where we're going to do a rigorous criminal trial beyond a reasonable doubt standard, full discovery, notice of charges is in a reformed military commission. Okay, and then finally, un-American, my last comment. Anyone who wants to call military commissions un-American should, go ahead and do it. But think about the historical example of John Yates Bell. And I take you back to 1865, February of 1865. Abraham Lincoln is reviewing the military commission conviction of John Yates Bell. Bell was a Confederate officer operating in upstate New York in late 1864. Was convicted by military commission for having sought to derail a civilian train. He was attacking civilians, the oldest crime we've got, right, in modern humanitarian law and law of armed conflict. Violating this principle of distinction between combatants and non-combatants. Bell was operating without wearing his uniform. He's in New York. Civilian courts are open in New York. He gets tried by a military commission. Think about what Lincoln's doing at the time as he's reviewing it in February of 1865. In January of 1865, he has just succeeded in getting through the House of Representatives the 13th Amendment to the Constitution, right? This is popularized in the recent film. Getting through the House of Representatives the 13th Amendment, seeking to make permanent the Emancipation Proclamation that he issued earlier in the war. That's what he's doing in January. What's he doing in March? In March, he gives his second inaugural address, one of the most sublime statements in our culture about might not being equated with right. In between those two iconic moments in our modern constitutional democracy, Lincoln is approving the military commission conviction of John Yates Bell. Now that doesn't settle the rightness or wrongness of military commissions in the 21st century. It doesn't even settle Lincoln's controversial record on civil rights in wartime, but it certainly gives you pause when you want to call military commissions un-American, I would submit. So let me stop there.